If you over-prepare for your deposition, is it going to impact your case? Will it impact your credibility? Will it make a difference in how the defense lawyer sees you as a potential witness at the time of trial? Would you like to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so here's the scenario. You brought a lawsuit against your doctor claiming that he was careless and caused you significant harm and injury. Now, during the course of your lawsuit, you will have to answer questions by the attorney who represents the doctor whom you have sued. We call this a deposition. Lawyers also call it an examination before trial. This is really a question and answer session that takes place in pre-COVID times in our office. Now, during COVID times, it typically takes place on a Zoom video call. I would be there. The defense attorney would be there. The court stenographer would be there to record all of the questions that you are asked and all of the answers that you give. And you should know something. The answers that you give represent your sworn testimony. And it carries the same exact weight as if you are testifying at the time of trial in front of a judge and in front of a jury. So it's a very important part of your particular lawsuit, and it locks in your testimony. So now let's get back to the question I raised in the title of this video. Is there a danger to you being over-prepared for your deposition? In my opinion, the answer is yes, there is. There are some people who are so focused on wanting to answer every single question correctly, wanting to give an answer to every single question and do it as accurately as possible, that they will try and over-prepare, like studying for a test. They will ask for various documents. They will want to see medical records. They will want to see various reports. And then they will study them, and they will go through them, and they will prepare and read them over and over and over again. So now, as you get closer and closer, now they have refreshed their memory about every single event that transpired, and now they know exactly what happened, and they are ready. They are fully ready after spending days and weeks getting ready for this question and answer session. The one dilemma, the one problem that arises when a witness over-prepares for their deposition is that it seems totally unnatural. You see, many people don't realize, but this question and answer session almost seems like a conversation. Now, it has much more significance and many more implications than a simple, innocent conversation that you have with somebody over the kitchen table or when you go out for some coffee on a Sunday morning. The implications are that this attorney is not asking you questions just for his benefit. He's asking you not just to learn what happened, but to lock you into your testimony so when and if your case goes to trial, you can no longer change your answers at the time of trial. And if you do so at your own peril, because now you will have contradicted yourself. Okay, so over-preparing means that you are going to come across as usually stilted, as giving rehearsed, canned answers. And you know what? It's not natural. And as much as you prepare for it, and as much as you practice, it's not going to be natural when an attorney asks you a question, because now you're trying to remember the exact answers that you rehearsed in preparation for various questions. So if you're asked, hey, Mrs. Jones, when did you see Dr. Gonzalez? Oh, I saw him January 1st. Okay, tell us what you said to the doctor. And now you begin to rattle off a detailed historical conversation. Okay, and what did Dr. Gonzalez do? And now you begin to describe in exquisite detail every single thing that he did. Well, he took a history, and then he took my blood pressure, and then he did this, and then he drew my blood, and then he did an examination. And now this goes on and on for every single interaction, every single visit. It's as if you have memorized every single answer to every potential question. And that comes across as not being totally credible. The better practice is not to over-prepare, which is why I prefer to prepare my clients close in time to when they are actually going to be questioned. And when I say the word prepare, by no means does it mean I give the answers to my client. That's never what it means. Although many people in the public have that perception that that's what attorneys do when they prepare someone for their pretrial deposition. They think that the attorney tells the witness how to answer the questions. They think that the attorney puts words in the witness's mouth on what to do if they're asked about a certain topic. The reality is that no, that's not what happens. What really happens is that we refresh your memory. We go through the exact questions that we believe the defense will be asking you. And now what it forces you to do is to try and recall the answers to those questions. And now, as you go through it, if you're stuck, we can refresh your memory based upon records that we have and say, hey, Mrs. Jones, I just want to let you know the medical record for this doctor indicates that you saw him on January 1st. Does that refresh your memory? Things like that. Now, when it comes to conversations, those are not recorded anywhere in the medical records most of the time, unless they're phone messages. So can being over-prepared for your pretrial deposition destroy your case? Maybe not destroy your case, but certainly impair your credibility. And the better practice is, you don't need to be over-prepared. You already know the details of what occurred. And if you don't, I guarantee you that your attorney, someone worth the salt, is going to prepare you and refresh your memory so that you do, to the best of your recollection, do remember certain things. And finally, the last point I want to mention, if you don't know the answer to a question, it's perfectly acceptable to say, I'm sorry, I don't know. Or, you know what, I don't recall that at this time. It's been a number of years since this event happened, and I just don't remember as we sit here today. And that's perfectly okay. But keep in mind that if your case goes all the way to trial, and now you're up on the witness stand testifying and you're asked that same question, if you are now to all of a sudden remember those details that you did not remember during your pretrial question and answer session, now the attorney would pull out the transcript to show that there is a contradiction between what you said a year earlier and what you're saying now at trial. So why do I share this great information with you? I share it with you because my wife is now all the way down the beach picking seashells, and I have a few minutes to share this with you and open your eyes to what really goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. I realize you likely have questions or concerns about your own matter. If your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.